CIV PRO 1. This is personal jurisdiction, subject matter jurisdiction, and venue. Part 1 for the 2024 bar. First of all, personal jurisdiction. 2 prongs. 1, we must satisfy the requirements of general or specific jurisdiction, and 2, satisfy due process. What must be due to obtain personal jurisdiction? We have to satisfy general PJ, specific PJ, and we must satisfy what? That's right, due process. So in every essay discussing personal jurisdiction, step 1, we must satisfy what? That's right, general jurisdiction or specific jurisdiction, and satisfy 2, due process, which of course is notice and opportunity to be heard. Let's go into types of personal jurisdiction. In personam, over the person. In rem, determining the rights to property, not people. Okay, one note about in rem. It's to determine the rights to property located within the state's borders. So in personam, easy. In rem, property located where? That's right, within the state's borders. In rem, the property has to be located where? Within the state's borders. And quasi in rem, the plaintiff is seeking to enforce what kind of right? A property right. What's a property right? A lien, or use the defendant's property to satisfy some sort of judgment. The defendant is trying to use the plaintiff's property, attached to plaintiff's property, in order to gain PJ over the defendant. 2 prongs. Defendant has to have minimum contacts with the forum state. And 2, the judgment is limited to the value of the property. We'll discuss minimum contacts in a moment. But quasi in rem, state the general rule. That's right, the plaintiff is seeking to enforce a right or use the defendant's property to obtain personal jurisdiction over the defendant and thereby enforce that property right. What's the judgment limited to? That's right, the value of the property. And the defendant has to have what kind of contacts with the forum state? That's right, the defendant has to have minimum contacts with the forum state. Okay, owning property in the forum state that's subject to a lien or a judgment would probably be sufficient to satisfy quasi in rem jurisdiction. Okay, so now how do we get personal jurisdiction over the defendant? PJ exists if there is a statutory basis, in other words, the long arm allows it, at the time the action was commenced. What's the statutory basis? It's always, that's right, the long arm statute. If there's a statutory basis, in other words, it satisfies the long arm of the state, then we can get PJ over the defendant, or actions that gave rise to the suit. Okay, so we get PJ over the defendant if there's a statutory basis, in other words, the long arm, and or the defendant's actions in the forum state gave rise to the suit. When is there PJ? It's not just time of filing, right? It's at the time the action was commenced. On the MBE, there actually are questions that test when a plaintiff moves. The action is commenced not just when the action was filed, but also if there was an injury had and the plaintiff moved. That doesn't destroy PJ over the defendant for diversity purposes. Okay, so PJ exists if there is a, that's right, statutory basis, meaning the long arm at the time the action was commenced, which means plaintiffs that move don't affect diversity cases. And the exercise of PJ, so there's action, so it's statutory basis at this time the action was commenced. Actions gave rise to the suit. Later moves don't matter. 2, the exercise of PJ comports with due process. Okay. PJ exists if there's a statutory basis at the time the action was commenced. The exercise of PJ comports with due process, and it is reasonable. 1, statutory basis. 2, comports with due process. 3, reasonable. 1, that's right, statutory basis or the long arm at the time the action was commenced. 2, comports with due process. And 3, reasonableness. There are 4 factors that determine reasonableness. They are easy. 1, the plaintiff's interest. 2, the forum state's interest. 3, the burden on the defendant. And 3, the judicial system's interest. 1, plaintiff's interest. 2, forum state's interest. 3, burden on the defendant. 4, interstate judicial system. 1 is plaintiff's interest. 2 is, that's right, forum state's interest. 3 is, that's right, the burden on the defendant. And 4 is the interstate judicial system's interest. Let's expand on those a little bit. It's the plaintiff's interest in having the suit heard in the forum state. The plaintiff decides where to sue. The forum state's interest in having the suit heard there. Was someone injured in that state? Do they have an interest? The burden on the defendant. Does the defendant have to travel? Is all the evidence located in another state? The interstate judicial system's interest in the efficient administration of justice. So the interstate point for the judicial system's interest is always efficient administration of justice. How can we get PJ? We've got the big 5. How do we get PJ? Domicile, consent, waiver, tag, or specific jurisdiction. What are the big 5? 1, domicile. 2, consent. 3, waiver. 4, tag or transient jurisdiction. And finally, that's right, specific jurisdiction. You are always going to look for a PJ issue when the defendant is not being sued in their own state. Repeat, always look for a PJ issue whenever the defendant is not being sued in their own state, because it is fair to sue the defendant where the defendant resides. Okay, when do we have general PJ? Well, we have, that is domicile, consent, waiver, or tag. Domicile, consent, waiver, or tag grant general personal jurisdiction. So 4 out of 5, general PJ. Domicile, consent, waiver, tag, we get general PJ. Domicile is, of course, what? Fact of residence and intent to remain. Fact of residence, intent to remain at the time of what? Commencement of the action. Domicile, fact of residence, intent to remain at the time the action is, that's right, commenced. Okay, for an individual, do courts just have to take the defendant's word for it? No. A court may examine property and tax records to determine domicile. And this came up on the MBE recently. Remember, a corporation has dual citizenship under Hertz, their principal place of business or their nerve center, and the place of incorporation. When you're analyzing diversity, don't forget to diagram the corporate defendant. Okay, so where is a corporate defendant domiciled? Yes, their principal place of business or nerve center, and their place of incorporation. And there's also the third rule. General and systematic affiliations with the forum state, such as to render them substantially at home. Okay, so there's principal place of business, nerve center, place of incorporation, and then there's the substantially at home test. A corporate defendant is domiciled in a state if they're incorporated there, if their nerve center is there, or if they hit the substantially at home test. That's right, general and systematic affiliations, such as to render them substantially at home. That's a high bar. Okay, so we just went for domicile for an individual or a corporate defendant. Speaking of which, where is an unincorporated association domiciled? The location, it's the state of citizenship of any of its members. Okay, working through again, consent, general personal jurisdiction, domicile, consent. Okay, consent can of course be express or implied. Implied consent would be the defendant's actions arise from their wrong that they did in the forum state, right? Remember, it's fairness, plaintiff's interest, forum state's interest, burden on defendant, interstate judicial system. Is it reasonable? If the defendant's actions arise from the forum state, we have general PJ over the defendant. Also, consent may be implied if someone appears in court or answers a pleading. So we have consent, expressly a consent, implied, the defendant does some harm in the forum state, or the defendant consents by appearing in court or answering pleadings. Note, this came up on the MBE. A plaintiff may appear in court verbally and object to the court's jurisdiction. Yes, a defendant may show up in court, attack the court's jurisdiction, and that doesn't waive the right. However, let's discuss waiver and how that would work. So, general personal jurisdiction, domicile, consent, and waiver. If you waive it, you've appeared in court, you didn't object in your first 12B1 motion or in your answer, you signed a contract in the state, and you can waive PJ by appearing in court and verbally attacking the court's jurisdiction without waiving. One caveat, if you assert any claim or request any relief, you just waived, you just consented. Okay, you can waive PJ by appearing in court, but if you just challenge the court's jurisdiction, you haven't waived. You assert any claim for relief, guess what? You have waived, you've consented. Remember, in a motion to dismiss any 12B motion, if you don't raise PJ in that first motion, you cannot later raise it in the answer. Finally, tag, the one that's kind of the most unfair. General PJ is conferred when the defendant is served while personally was served with process, temporarily and voluntarily in the forum state. So tag, or transient jurisdiction, grants general PJ when defendant is personally served with process while temporarily and voluntarily in the forum state. Of course, you can't lure the defendant or force the defendant into the forum state or serve the defendant while the defendant's there just to appear in another legal proceeding. So those are our exceptions: luring the defendant into the forum state, serving there while they're in there on a different legal proceeding. But I have seen an executor exception. Remember, the executor's citizenship is immaterial. But if we want to serve an executor in their representative capacity as an executor, we can't just serve them while they're on vacation in the forum state. That was on the MBE. You can't lure the defendant in the forum state, serve them while they're there on a different legal proceeding, or serve an executor or a trustee when they are in their representative capacity when they're just there on vacation. That's Henson versus Denglaw. Okay, so tag, what's our legal standard? Transient jurisdiction grants general PJ when defendant is personally served with process while temporarily and voluntarily in the forum state. You can't do what? Lure the defendant into the forum state. 2, serve the defendant while they're there on a different legal proceeding. Or 3, that's right, serve an executor in their representative capacity when they're on vacation there. Okay, so that's our general PJ: domicile, consent, waiver, and tag. Specific personal jurisdiction. If it's not general, it's specific. We get specific personal jurisdiction if we have 2 things. 1, defendant's actions in the forum state gave rise to the lawsuit. 1, easy. Defendant's actions in forum state gave rise to the lawsuit. That is 1. Don't forget it. It's not just sufficient minimum context. We get specific PJ if 1, defendant does what? They act in the forum state. They do harm in the forum state. They do business in the forum state. That is part 1. Specific PJ has 2 parts. You need both. 1, defendant's actions gave rise to the lawsuit. That is number 1. Do not forget it. Number 2 is, of course, sufficient minimum context with the forum state, that the defendant could have reasonably anticipated being hailed into court there. That's Burger King. Sufficient minimum context with the forum state such that defendant could have reasonably anticipated being hailed into court there. And 3, so as not to offend traditional notions of fair play and substantial justice. All right, let's break that down a little bit. Do not forget part 1. Part 1, specific jurisdiction. Defendant's actions in the forum state gave rise to the lawsuit. 2, sufficient minimum context with the forum state such that defendant could have, that's right, reasonably anticipated being hailed into court there. We're going to break that down into 3 things. 1, purposeful availment. 2, targeting. And 3, the Calder effects test. So sufficient minimum context with the forum state such that the defendant could have reasonably anticipated being hailed into court there. Okay, the purposeful availment test means that the defendant received the benefits or the protection of the forum state, including the privilege of doing business there. A defendant purposely avails themselves of the forum state when they receive the benefits and the protections of the forum state, including the privilege of doing business there. What's purposeful availment? The defendant received, that's right, benefits and the protections, including the privilege of doing business in the forum state. So sufficient minimum context. 1, purposeful availment. What did the defendant get? They got the benefits and the protections of the forum state, including the privilege of doing business there. Sufficient minimum context, targeting. The defendant targeted the plaintiff in the forum state, meaning they derived economic benefit from their activities in the state. Targeting derived economic benefit from their activities in the forum state. So purposeful availment, what happened? Defendant received a benefit or the protections of the forum state. Targeting, they got economic benefit from their activities in the forum. They targeted the plaintiff in the forum state. So purposeful availment is a little bit more general, right? They just received the benefits, the protections of the forum state, meaning they traveled on the roads, they did business in the forum state, they benefited from anything in the forum state. But targeting is more specific. We're targeting the forum state, getting economic gain from plaintiff in forum state. That's targeting. Calder effects test, number 3. The defendant committed an intentional act, harmful act, aimed at the forum state, and it caused harm to the defendant in the forum state. So 1, purposeful availment. That's right. They received the benefits and protections, including the privileges of doing business. 2, targeting. Defendant targeted who? The plaintiff in the forum state and gained economic benefit from that activity. And 3, the Calder effects test. The defendant committed what? An intentional act, defamation, aimed at a person in the forum state, and it caused them harm. Okay, specific PJ, what's part 1? Part 1 is the defendant's actions gave rise to the lawsuit. Number 2 is sufficient minimum contacts, purposeful availment, targeting, or the Calder effects test. And of course, it must not offend traditional notions of fair play and substantial justice. Okay, so this means that these minimum contacts have to be undertaken by the defendant such that it is foreseeable that the defendant might be sued there. That's worldwide Volkswagen. Okay, fair play and substantial justice is, of course, international shoe. But it has to be foreseeable that the defendant might be sued there. Okay, getting back to foreseeability, if we're talking stream of commerce like worldwide Volkswagen, we're always talking specific jurisdiction. Stream of commerce cases are always specific jurisdiction. The defendant purposefully placed its products in the stream of commerce. That's not enough. It must be what? Foreseeable that those products would get to the forum state. That's worldwide Volkswagen. The defendant purposefully placed their products in the stream of commerce, and it was foreseeable that those products would end up in the forum state and cause harm. Worldwide Volkswagen. Or the defendant took a specific action to market the products in the forum state. Stream of commerce is always what kind of jurisdiction? Specific. Based on what? The defendant's contacts, and it turns on foreseeability. The defendant placed its products in the stream of commerce. It was foreseeable they would end up in that state. Or they took specific action to market products in the forum state. That's McGee versus International Life. Once is enough. All right, we're going to pause for a minute to plug in our computer. E-commerce is always going to turn on what? The level of interactivity. Passive website, the Zippo test. If it's passive, it's probably not stream of commerce. If we have a lot of commercial activity in the forum state, then we probably will get specific personal jurisdiction over the defendant. All right, so let's go over step 1 real quick. We need to satisfy general and specific jurisdiction in personam, in rem, or quasi in rem. And we get personal jurisdiction if there is a what basis? Statutory basis, meaning we satisfy the long arm. And later moves by the parties don't affect the jurisdiction because the statutory basis exists when the time the action is commenced. So there's the statutory basis, it comports with due process, and it is reasonable. Statutory basis when the action is commenced, exercise of PJ comports with due process, and it is reasonable. The plaintiff's interest, forum state's interest, burden on defendant, interstate judicial system's interest. And now we have the big 5, how we get PJ. When are we going to look for a PJ issue? That's right, whenever the defendant is not being sued in their own state. And here we have the big 5. General PJ, domicile, consent, waiver, tag. Specific PJ, specific jurisdiction based on minimum contacts. Okay, let's go through number 4. Domicile, fact of residence, intent to remain. Property tax records, okay to prove. Corporate dual citizenship. What's the substantially at home test? The corporate defendant has such general and systematic affiliations with the forum state, such as to render them substantially at home. Number 2, consent, express or generally implied. The defendant's actions arise from their wrong in the forum state, or they consent by appearing in court or answering pleadings. They waive by appearing in court and asserting a claim for relief, by failing to object in the motion or in the answer. They're tagged while temporarily and voluntarily in the forum state. Temporarily and voluntarily in the forum state. Now, for specific PJ, we need both 1 and 2. 1 is the defendant's actions in the forum state gave rise to the lawsuit. And we have, that's right, sufficient minimum context such that the defendant could have reasonably anticipated being hailed into court there. And we've got our 3: purposeful availment, benefits, protections, privileges; targeting economic gain from a specific action in the forum state; Calder effects test; intentional act aimed at the forum state, harm to the plaintiff. And then we have to not offend traditional notions of fair play and substantial justice. So 1, the defendant's actions gave rise to the cause of action. We have sufficient minimum context so as not to offend traditional notions of fair play and substantial justice. Okay, minimum context. If it's a stream of commerce case, this is always going to turn on, that's right, foreseeability. Is it foreseeable that the products would end up in the forum state, as in Worldwide Volkswagen? Or did the defendant take a specific action to market their products in the forum state, like McGee versus International Life? And then for e-commerce, passive website, probably no specific jurisdiction. Interactive website, maybe we are going to have specific jurisdiction. Okay, we just went through step 1. Step 1, we have to satisfy general and specific jurisdiction. Thankfully, satisfying due process, step 2, is a lot easier. To satisfy due process, we give the defendant notice reasonably calculated under the circumstances to apprise the defendant of the pendency of the action and afford him an opportunity to be heard. Mullane versus Central Hanover Bank. Okay, repeat that. To satisfy due process, we give the defendant notice, which is, that's right, reasonably calculated under the circumstances to, that's right, apprise the defendant of the pendency of the action and afford him an opportunity to be heard. And that is what case? Mullane versus Central Hanover Bank. To satisfy due process, that means notice and opportunity to be heard. Okay, repeat the rule again. Notice, reasonably calculated under the circumstances to apprise the defendant of the pendency of the action and afford him the opportunity to be heard. Okay, this necessarily involves service. And how much time do we get to respond? That's right, 21 days unless you waive, in which case you get 60. How many days is a summons valid? 90 days. You get 90 days to serve that summons, or it's invalid unless there is what? Good cause for failure to serve. You get 21 days to answer, 60 days if you waive. But on the plaintiff's side, how many days do you use? That's right, 90 days. In 90 days, it expires. And then you probably would go with substitute service. But the legal standard is what? Good cause. How is service made? By anyone over the age of, that's right, 18 who is not a party. Service is allowable under the FRCP by anyone over age 18 and not at a party. Okay, service on an individual. This is easy. Hand it to them personally or leave it at their usual place of abode with someone of suitable age and discretion who resides there. Serve it personally or leave it at the usual place of abode with someone of suitable age and discretion who resides there. What if the person destroys the service? Still valid. What if the person forgets they were ever served? Still valid. What if the third party destroys it? Still valid. Okay. Service on a corporation. Number 1, you can't tag corporations. Can you tag a corporation? No. A corporation is a legal entity, a legal person, but it has two domiciles, right? State of incorporation and principal place of business. Can a corporation ever be voluntarily and temporarily in the forum state? No, that's why you can't tag a corporation to get PJ. What do you do instead to serve a corporation? You serve their officer or the agent authorized to receive service of process. What about a partnership or an LLC? You can serve the partnership in the states where all members or partners are citizens. So if we have members or partners in all 50 states, we can serve them in all 50 states. A partnership or an LLC is a citizen of where all of the partners or members reside. Okay, two very important points. State law service. Okay, the MBE loves to test this question. Under the FRCP, if the state allows service by mail, that is permissible. But the question must explicitly state that service by mail is allowed. And when it states that service by mail is allowed, that is your legal standard. Service by mail must be allowed in that state, and it has to say so straight up in the question. Okay, we have one more scenario. What if the mail is returned undeliverable? That's right, you have to take additional reasonable steps. So if the state law allows you to serve by mail and the mail gets returned, are you off the hook? No, you must take additional reasonable steps. And this is Jones versus Flowers. Finally, and don't forget this, the 100-mile bulge rule only applies to impleaded defendants. Impleaded defendants. The 100-mile bulge rule, meaning that we get to serve a person within 100 miles of where the district court is located. That only applies when we're impleading a defendant. When does the 100-mile bulge rule apply? Only when we're impleading a defendant. Even where there's no minimum context, don't worry about that. We satisfy due process via the 100-mile bulge rule only for impleaded defendants. Okay, so while we're at it, we'll talk about the carrot and stick of waiver. We know this. We get 60 days to respond if we waive, 90 if outside the US. What happens if you don't waive? That's right, you pay the costs. Okay. Has the defendant waived any objections if they don't waive? No, they just pay the costs and they have to waive within the 21 days. They have to answer within the 21 days. So if you waive, great. You get the carrot, the 60 days. You decide not to waive, you get the stick. You pay the costs, but you haven't waived any of your objections. You just have the normal time to respond. Okay, so we just went through PJ. Let's go through, we just went through due process, notice and opportunity to be heard, service, waiver of service, and now let's talk about SMJ. Remember, SMJ is never waived. It can be raised at any time, even by the court on its own. On motion or on its own, the court can raise an objection to a defect in SMJ at any time, and no party can consent to waive it. So as a practical rule, we have our anchor claims and we have our piggyback claims. Can we ever consent to waive SMJ ever? No. Can the court raise an objection to SMJ at any time? Yes. And we'll cover a situation which a plaintiff or a defendant might save their subject matter jurisdiction. Okay. But of course, we have two kinds of anchor claims. But as a practical rule, we need one, federal question, or two, diversity. We know these. Federal question, there has to be a question that relates to federal law or the Constitution on the face of the plaintiff's well-pleaded complaint, defenses, anticipating defenses are not permissible, and that is, of course, Motley. The well-pleaded complaint rule. Federal question. Are we in court on a federal question? We will know that if it is evidenced by the face of the plaintiff's well-pleaded complaint. We can't anticipate federal defenses. Or 2, diversity, meaning complete diversity of citizenship at the time the action was commenced and our amount in controversy of $75K or more, exclusive of interests and costs. Don't forget that. It has to be exclusive of interests or costs. Okay, so remember, we need to have federal question or diversity. Sometimes it's easy to forget federal question because we're so focused on diversity. So we've got our diversity of citizenship of an individual, we know that, fact of residence, intent to remain, corporation based on domicile, unincorporated entities is the state of citizenship of each partner or member. Okay, what about aliens? Non-resident aliens. Can we sue somebody in a foreign country on diversity? Yes. Can 2 people from 2 foreign countries sue in the United States based on diversity? No. Aliens on one side of the V, diversity, okay. Aliens on both sides of the V, destroy diversity. So that's our rule from Professor Jones. Professor Jones. Aliens on both sides of the V, no diversity, no SMJ. No diversity jurisdiction if we have aliens on both sides of the V. And what about our amount in controversy? We have the $75K unless, legal standard, clear to a legal certainty that the plaintiff cannot recover that amount, not the judge's opinion, clear to a legal certainty. Okay, let's run through our aggregation rules. These are easy. Remember, the only situation in which aggregation is permissible is a single plaintiff against multiple defendants. That's it. A single plaintiff may aggregate against multiple defendants even if the claims are unrelated. Period. Multiple plaintiffs cannot aggregate with multiple defendants, ever. Multiple plaintiffs, multiple defendants, no aggregation, ever. The only time we get aggregation is if we have a single plaintiff aggregating claims, related or not, against multiple defendants. So what about multiple plaintiffs? Can they aggregate against a single defendant? Generally, no. Multiple plaintiffs cannot aggregate against a single defendant unless they share a common or undivided interest. What does this mean? Real property. Okay, let's run through that again. Our scenario, our aggregation scenario, may a single plaintiff aggregate against multiple defendants? Yes, even if the claims are unrelated. Multiple plaintiffs versus multiple defendants, can either side aggregate to meet the amount in controversy? No. How about multiple plaintiffs against a single defendant? Can they aggregate? No, unless they share a common or undivided interest, like real property. Okay, we'll go over class actions later, but just remember in class actions, we have that minimal diversity requirement. Okay, so we have our anchor claims: federal question, federal law on the face of the plaintiff's well-pleaded complaint, no defenses, has to be plausible, and diversity with the amount in controversy. And then we have, so those are our anchor claims, and then we have supplemental jurisdiction or our piggyback claims. The related state law claim piggybacks on the anchor claim. Step 1, relatedness. Does the claim arise from the same transaction or occurrence as the original federal question or diversity claim? If it's federal question, we need it for all defendants. Okay, for a federal question, we need a federal question for supplemental jurisdiction. On the other hand, if it's diversity, we have a slightly different scenario. Can the plaintiff bring So supplemental jurisdiction claim is our piggyback claim, related state law claim. Can plaintiffs destroy diversity? No, a plaintiff can never claim against a defendant and destroy diversity. They can't implead or join or add a non-diverse defendant ever, because the plaintiff can never destroy diversity, period. Defendants may bring claims that destroy diversity. So that's our diversity rule. For supplemental or piggyback jurisdiction, if it's federal question, we need federal question everywhere. All parties, all claims. Diversity, plaintiffs never can add parties that destroy diversity. Defendants can. And of course, supplemental jurisdiction is always at the discretion of the court, right? So they may just decline if 1, novel or complex issue of state law, 2, the supplemental claims predominate over the original jurisdiction claims, or 3, all federal claims have been dismissed and all we have are the supplemental claims. 1, that's right, novel or complex issue of state law. 2, the supplemental claims do what? Predominate over the original jurisdiction claims. Or 3, all federal claims have been what? Dismissed. And what's left? The supplemental claims. Okay, there are 2 testable scenarios, and they're always going to be over the supplemental claim. 1, where supplemental jurisdiction will apply, and 1 where it will not apply. One of these is compulsory counterclaims. Remember, a compulsory counterclaim shares a common nucleus of operative fact. It is so related to the original claim that it becomes part of the same case or controversy. Compulsory counterclaim, don't just say same transaction or occurrence. So a compulsory counterclaim is what? So related to the original claim that is part of the same case or controversy, such that, remember, it could be precluded if you don't bring it now. A compulsory counterclaim has to be heard because it is so related that it's part of that case or controversy. If you don't hear it now, it's likely what? Precluded. So supplemental jurisdiction, that's right, it applies. It applies even if the defendant's counterclaim is less than $75,000. It applies even if the defendant destroys diversity, because remember, defendants can bring claims that destroy diversity. Okay, supplemental jurisdiction applies to compulsory counterclaims. Why? Because they are so related to the original claim that they are part of the same case or controversy, even if they don't meet the $75,000, even if they destroy diversity. That's scenario 1. Supplemental jurisdiction will apply to a compulsory counterclaim. Supplemental jurisdiction will, 2, apply to impleading a third-party defendant. You can get supplemental jurisdiction to implead a third-party defendant, but only for what? When do we implead? That's right, indemnification or contribution from the third-party defendant. And of course, you can aggregate to get to the amount in controversy. If we have a single plaintiff, they can aggregate to get the amount in controversy. Okay, so supplemental jurisdiction applies to 1, compulsory counterclaims, and 2, impleading third-party defendants. Here's when supplemental jurisdiction does not apply to the piggyback claim. We already covered it. Number 1, the plaintiff tries to implead or join a defendant to destroy diversity. Who destroys diversity in a diversity case? Watch out. Don't get caught. Supplemental jurisdiction would apply if it was a federal question case. But if we're in court on diversity, the plaintiff can never implead or join a defendant who destroys diversity in a diversity case. Diversity case, plaintiffs can't implead defendants or plaintiffs who destroy diversity. You can't destroy diversity to get and your supplemental jurisdiction will not apply. You're never allowed to do it to get to the amount of controversy. You're never allowed to destroy diversity. Okay, supplemental jurisdiction does not apply to permissive counterclaims. Remember, a counterclaim, a compulsory counterclaim, will have supplemental jurisdiction. A permissive counterclaim may, if it has an independent basis for subject matter jurisdiction. Why is that? Because a permissive counterclaim, by definition, is not related. It is not so related that it forms nucleus of act. A permissive counterclaim will not get supplemental jurisdiction automatically. It must have, that's right, an independent basis for SMJ. What does this mean? It means they have to have the $75,000 plus in controversy. So we're in court on diversity. We have someone who counterclaims. It's not related. So it's what? Permissive. Is the counterclaim is $3,000? Do we get supplemental jurisdiction over that claim? No, the court will decline it. The claim has to meet the $75,000 plus. It has to meet the amount in controversy. If it's a permissive counterclaim, it has to have an independent basis for supplemental jurisdiction. 1, it's got to meet the amount in controversy. 2, it's got to have a federal question. Okay, finally, changes to the lineup of the parties also affect supplemental jurisdiction. Okay, so remember, changes to residence or citizenship don't do anything because the cause of action is fixed at the time it is commenced. But when we change the lineup of the parties, that rule doesn't apply. Let's say we have a plaintiff from state A, we had a defendant from state B, and we have a plaintiff who is from state B. Okay, now normally this would, if we're, let's say we are in court based on federal question, do we have a problem? No. If we're in court based on diversity, are we going to get in court? No. Unless plaintiff number 2 gets their claim dismissed. If the plaintiff who destroys diversity voluntarily dismisses their claim, we've got a state A, state B situation, right? Diversity will be saved because the relation back doctrine will apply even if the SOL has run. Okay, so changes to the lineup can save a diversity case if the party that destroys diversity drops out or gets their case dismissed. Okay, so supplemental jurisdiction applies to compulsory counterclaims, impleading third-party defendants. Supplemental jurisdiction does not apply to what kind of counterclaims? Permissive. And a plaintiff can never do what? Implead or join a defendant who destroys diversity in what kind of case? A diversity case. Watch out for federal question. Changes to the lineup can save diversity jurisdiction. Okay, finally, we have removal. Only defendants can remove, and only to where? The district court that embraces the state court where the case was filed. Only, that's right, defendants can remove, and only to the district court that embraces the state court where the case was filed. What do we need for federal court? The case has to have been eligible for federal court originally. In other words, you've got to be in federal court based on federal question or diversity. Okay, so the federal court obviously has to have SMJ over all the claims, the federal question claims, the diversity claims, and the supplemental claims. And when's our deadline? 30 days from when the grounds become apparent. Removal, 30 days. How long do we get to remove, Mr. Defendant? 30 days. If we have multiple defendants, that's right, all must join in the notice of removal. And a newly served defendant, that's right, restarts the clock. We get 30 days to remove. But if we have a newly served defendant, it's 30 days from service of the last defendant. Okay, so what's our absolute deadline then if we have multiple defendants? It's a year, 1 year. Single defendant, 30 days from when grounds become apparent. Multiple defendants, restart the clock, but we can't go later than 1 year. Okay, here's a scenario that came up on the MBE. The defendant exercises their right to remove the case, but they fail to answer the complaint within 21 days. What happens? They risk default. The defendant must answer the complaint within the permitted time frame, or they risk default. So you get 30 days to remove, Mr. Defendant, but you've got to answer within that 21 days, or 60 days if you waived. Okay, so let's talk about removal on federal question. If we want to remove on federal question, of course, all claims have to have federal question. But what happens if we want to remove on federal question and one or more of those claims don't have federal question? Is the whole case going to be dismissed? No. The court will do what? Sever and remand non-federal question claims. We remove on federal question. Any non-federal claims get severed and remanded. Okay, removal on diversity. Okay, so the home state defendant rule is what? The defendant can't remove a diversity claim if any defendant is a citizen of the forum. Watch out, don't fall for it when the MBE says they're in court based on a federal question. If they're in court based on a federal question, a home state defendant may remove. What's our home state defendant rule? The defendant can't remove a diversity claim if any defendant is a citizen of the forum state. Home state defendant rule only applies to diversity cases. Okay, remanding. So we just talked about remove. What about remand? The plaintiff has 30 days to move to remand the case if the case was improperly removed. 30 days to remand. Plaintiff has 30 days to remand. How long do they have to remand? Oh yes, 30 days. How long does the defendant have to remove? That's right, 30 days. And multiple defendants do what? That's right, they restart the clock. Okay, what about if we have a defect in SMJ? Do we have a time limit? No. Defects in SMJ, any time. Okay, scenario. The plaintiff is a citizen of state A, the defendant is a citizen of state B. We're in court in diversity, and halfway through the trial, the judge finds that the defendant is actually a citizen of state A. Does the case get dismissed? No, this is not forum nonconvenience. The judge remands it back to state court, must remand back to state court, even if the time limit has passed, because a defect in SMJ may be raised at any time. So the plaintiff has how many days to remand? 30. Is there any time limit if there's an SMJ defect? No. If the trial judge halfway through the case discovers that the defendant's citizenship actually makes the parties non-diverse, they must remand. They don't dismiss, they remand. While we're at it, let's talk about forum nonconvenience. Forum nonconvenience is, of course, our dismissal without prejudice, but it's not just because the trial judge found out someone's citizenship has changed. It's a dismissal without prejudice before the action commences or really gets started, to file in a more appropriate court based on the location of witnesses, evidence, records. We have a more appropriate choice of law. There's hardship to the defendant. Forum nonconvenience is a dismissal without prejudice, to file in a more appropriate court. That's different from remanding the case. Okay, let's talk about venue. Final topic. Venue. You don't object to venue, you waive venue. You have to raise it in your first motion or in your answer on the MBE. If you don't raise it in the first motion, you cannot later raise it in the answer. This has been a question. Okay, let's talk about the venue rule. Venue is proper in a district where any defendant resides if they all reside in the same state, or where a substantial portion of the events or property giving rise to the claim occurred, or fallback wherever the defendant is subject to PJ. We know this rule. Okay, so if we've got one defendant, we've got one district. If we have multiple defendants, it's any district is fair game. All the defendants reside in the same state, you can file venue is proper in a district where any defendant resides. Okay, what about non-resident aliens? You can sue them in any district. What about a corporate defendant? You can sue them where they're subject to PJ. Okay, but we're going to follow our dual citizenship or our substantially at home test. Okay, let's repeat the rule. Venue is proper in a district where any defendant resides if they all reside in the same state, or where a substantial portion of the events or property giving rise to the claim occurred, or fallback wherever the defendant is subject to PJ. Non-resident aliens, sue them anywhere. Multiple defendants, where any defendant resides, if they all reside in the same state. Okay, let's talk about transfer of venue, and then we're done. So the court may, remember it's discretionary, transfer for 1, that's right, convenience of the parties. 2, that's right, the interests of justice. Or 3, consent. What does it mean to transfer for convenience? Well, it could have been filed in that other form in the first place. We want local matters decided locally. Maybe the transferee court is, they could better enforce the judgment. Interests of justice means if it's filed in an improper venue, we're going to transfer where it could have been filed originally. Or by consent. So convenience of the parties, interests of justice, and consent or agreement. All right, so anyone can move to transfer on motion. It's permissive, or the court may do so on its own. The transfer court, why are we doing this? Because the transfer court has to be a proper venue. If it's a proper venue, what law applies? The law of the original venue. If you file in an improper venue, you get the choice of law of the transferee court. You filed in an improper venue, why? Because you wanted their statute of limitations. Guess what? You get the choice of law of the transferee court. One other thing, and that's the adequate alternative inquiry test. So the court may transfer for the convenience of the parties, the interests of justice, or consent. If there's consent, the defendant must offer an adequate alternative venue that can provide a remedy to the plaintiff. Okay, it's been over an hour. We are done.